constitute a bench made a finding that the petitioner was found guilty of an offense of addressing the gallery. His lawyers, all of them, never addressed the court. The lawyers were not addressing it. It is the petitioner who was addressing it. You have already made a decision that the petitioner was addressing the gallery. We really have confidence to appear before you. Ahmed Nasir Sr., when he was constantly spotted by the Supreme Court that he was attacking the courts, the court decided to punish. When he appeared, all the members of the Supreme Court recused themselves. They never gave him audience. Will the deputy president have audience before you when the main substantive motion comes before you? You have already made up your mind that his job is to address the public. The rationale for this matter, going live and my brothers and sisters saying it's a public interest matter, is because 55 million Kenyans are waiting to see the free learned judges appear impartial. It is our submission from our plant Sheria Mtaani that based on that, you recuse yourself. I'll give a small analogy. When I went to pay dowry for a friend of mine, we were told that that place, those people were witches. So that religion, when food is being prayed for, you must close your eyes. We never closed our eyes because behind us we fear, my Lord and my lady, that these guys might destroy us. The petitioner is scared of this page. That's why.
Are we through with all parties supporting the application? In that case,
and thank you, my Lord, and members of the bench. I will try to be brief. My colleagues and I, we, I think, would like to be truthful. First, we would like to begin by observing that today is the 10th day since this bench was constituted. It was constituted on the 14th of October. There were petition 522, petition 550, petition 565. Nobody ever complained at all until we came here on Monday. And even then, the complaint was an ambush. The petitioners appeared before my Lord Judge Ogola on the 16th of October. Orders were made in their favor. They were extremely happy. No complaint. The three judges of this bench were in the bench in 522 of 2024. No complaint. This complaint is a complaint founded on the fact that on the 18th, the Honorable the Attorney General, for the first time, also got orders. Now that is when this bench became a bad bench. It was a very good bench for as long as it gave any order to the petitioners. It became a suspicious bench when it gave an order, only an order to expedite the hearing. The Attorney General had wanted many things. They were all declined. I will address you, my lords, on the understanding that we have two petitions. There's one petition I call the Kerugoya petition, and there is another petition I will call the Nairobi petition. It is our preliminary submission that yesterday's ruling of the 23rd substantially addresses the issues raised in the Kerugoya petition, and that those issues are now, they are restituted. There is issue estoppel. There is issue estoppel, a doctrine of law that states a question that has been resolved by the court cannot be litigated afresh in the same proceedings. It is our second submission that the first limb of the Nairobi petition on recusal that speaks to how the case was handled between the 18th and the 22nd is also substantially settled by yesterday's ruling. And I think my learned friends, most of them, were able to confirm that. And they complained about that. So what issue is alive? The only issue that is alive is the issue of recusal, allegedly on the grounds that I'm so happy that my lady has been spared any further unwarranted attack as regarding her standing. So I will not make any reference to that. It has been considered that it was made recklessly, without any factual basis. And I think that what an ethical advocate of the Honorable Court should do is to start by saying, I apologize to her leadership for these allegations that are contained in a document that bears my signature. But that is not for me to say. So let us proceed to the two other allegations. At one point, I was very surprised to hear a submission that said that my Lord Justice Ogola is close to his wife. How can that be? How can that possibly be a bad thing?
Recently married.
But a further extension of that argument was equally spurious. A professional person is entitled to an independent professional existence. Be it the husband, be it the wife, be it siblings, be it children, they have independent professional. And I am shocked that that can be a ground. Another ground now made is that the Honorable Justice Mrima is a friend of the Speaker of the House. The Speaker of the House was my student. I don't know whether I should recuse myself. My Lord, if I may say this with respect, I have been a law teacher for 38 years. I apologize that that's not very long. There, 3/4 of the lawyers under the age of 50, I have taught them. I don't know whether I should recuse myself each time I appear against, including the Honorable Ndegwa Njiru here, Senator. You confirm that?
I confirm that you're my teacher.
and Senator, the Solicitor General, the Attorney General. This is the nature of our profession. This is the nature of our profession. The Speaker is a member of the legal profession. The Honorable Justice Mrima is a member of the legal profession. How else are we to do our work? Paul Githu Muigai, senior counsel, a personal friend for many years. On the day I got married, he brought me a copper coffee dispenser. Am I never to do any case with him? Should I always tell people, I know Paul Muigai from when I was mayor, he came to my wedding, he brought me a gift. It cannot possibly be. That is not how this profession works. Let me very quickly set this, what I believe, we believe, is the standard. The standard is set in the case of, most important of this all, is the right case, which has been talked about. When will you ask for a recusal? And I agree with Dr. Camino when he says that no lawyer, no advocate should ever make an application for recusal lightly. Indeed, an advocate approached by a client who is making personal attacks against a judge that are baseless must return the brief to the client. That is the honorable thing to do. Now, I have referred you to the right case, but the most important of this all is the objective test that is set in the Rawal case. In the Rawal case, which you are aware of, Rawal versus Judicial Service Commission, the court says there is no basis for a judge to automatically recuse themselves when a bare allegation is made by a party. The allegation must be substantiated. First, they now quote the court of appeal. Firstly, it is obvious from the above test that there is no basis for the rather elastic test propounded by Dr. Camino, where a judge must automatically recuse himself or herself upon the making of a bare allegation of any of the parties.